and welcome back to another Tuesday Tips at 2 with the Goldbergs. It's been a while, you've been missing us, we've been missing you, so let's get going. So, today we're going to cover what you should be doing up before and when you start up a partnership. We do a decent amount of litigation of when things go wrong between the partners. Here, hopefully, I can help you get them right on the front end. Got your pen? Got your paper? Good. Start writing. First thing first, you got the idea, you got a partner you're excited to start up with. Don't go filing for an LLC. Don't do it yet. Ask yourself this question: do you trust this human being? If it's someone that you know and love dearly, great, excellent, trust is there. But then you might ask yourself, do you really want to destroy this relationship in case things go wrong at a later point and you don't get along with this person? Separately, if it is someone that you might not know, it might not be your family, but you've met them, things are looking good, do you trust them for other reasons? Is their background good? Do they have a criminal history? Have they screwed previous partners? Do they have a track record of hard work, good work ethic, and trustworthiness? Credibility, that is. If the answer is yes and you're ready to move on, then have a very long conversation or set of conversation about what the proposed divisions will be between you and the partner or partners as to contributions, that is the investment. What to do if there is a need for future contribution because the costs that that y'all incur later on are more than is sitting in the bank. How do you divide up profit? How do you divide up labor? And most critically, how do you divide decision making? Here's a hint. If everything is 50-50, oh great, no problem. Decision making is going to run into a problem when you need a tiebreaker because you're saying this and he's saying that. What do? You dissolve the company simply because there's no easy fix? Well, there can't be an easy fix. Think about that on the front end. It can be something as simple as I make decisions as to all of these issues, and you make decisions as to all of these issues. Or it could be, hey, in case we're at loggerhead, the tiebreaker will be another third party that we call on in, and whatever his decision is as to the tiebreaker, then we respect it. One way or another, have these conversations, and here's another point: assume the worst. Everyone starts off these partnerships thinking, oh, it's going to be great, we're going to make so much money, oh, good times, what could ever go wrong? Assume the worst, assume there are going to be problems as you're discussing and as you're planning. Then, with all of that, you then go to a competent lawyer, a transactional lawyer. I'm a litigator. I've drafted up some of these agreements before, and I've even done it for myself. And that's simply because I know somewhat of what to expect, what is needed, etc. But it's not a substitute for a proper transactional lawyer that does this all the time, always, as their job. Sit down, tell them everything that y'all came to an agreement about, and then have him or her ask you the questions that they need to ask so that they can get this all finalized. Once that is all drafted, then sign it and make sure that the other side signed it too. Next up, before you go file for the company, put together a proper 3-month cash flow forecast. This is something I didn't do when I started off my business, and I wish that I had. It's something that you can do with your accountant or just on your own, where you forecast what your estimated costs will be for the first 3 months, and then see how much money do you need sitting in the bank to cover all of those, assuming that you make no money on the front end. It could be that the partnership needs a whole lot more than 3 months. You know, a pizza shop opening up should know within 3 months whether or not it's earning money, or should have money really coming on in as soon as it opens up the shop, even if it's not very much, which is completely different than research and development for some new product that won't go online up until a few years have gone on by. In that case, you need more than 3-month cash flow forecast. Then round up the contributions, make sure all the cash is sitting in the account, and then you can open up your actual company. The company itself, whether it's an LLC, limited liability company, or an LP, limited partnership, or an incorporation, those are big decisions. Make them with your attorney. He can advise you this way or that way, or we can have another Tuesday tip or two about that topic. Not right now. And then you're starting you're moving, hire an accountant or bookkeeper, have them track everything, have this information be available to everyone always. Never hide anything, never hold things behind from your other partner, especially if you're the manager or you're in charge of the finances. There's no reason to it. Be as transparent as possible, always. And then when, not if, but when a problem and a disagreement arises, stop, breathe, wait for the moment to pass, go on home, calmly read the agreement that y'all drafted and signed between the parties, and think about, okay, there's a disagreement. How should it be handled? Who's in charge of this category of decisions? What do we do? Check the agreement. If it's there, then you have nothing to worry about, because whatever y'all previously agreed to, that's what will be. And then you can go speak to your partner about it. Guys, partnerships is the greatest way to divide up labor so that not everything in a business and in a business startup is on just one person, but there's so many pitfalls and it leads to such hard, mean litigation because there's emotion and there's money and there's time and effort and trust and betrayal, and all these issues get all wrapped up into one, but it can be avoided with proper planning on the front end. Until next time, God bless and have a wonderful 2022.